Good evening, ladies and gentlemen, and welcome to the Worcester Township Board of Supervisors business meeting for August 20th, 2025. Would you please join me in saying the Pledge of Allegiance? Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. My name is Rick Lello. I'm the chairman of the board. To my left is Lou Betts, who's our vice chair. To my right is Steve Quigley, who's our third member. Over at the side table in the front, we have Wendy McKenna, who's here as our township solicitor, and John Everts, who's here as our township engineer. On the back table, we have Christian Jones and Dave Davino, who are our assistant township manager and township manager, respectively. First and foremost, does anybody have any informational items for the board tonight?
Yes, Mr. Chair, this meeting is being video recorded for broadcast.
Thank you, Christian. First item up on the agenda is public comment. We do ask that you limit your public comment to 5 minutes. Does anybody wish to make public comment to the board this evening? Take you right in front. Come forward. Just have a seat at the table if you would. Fill your name in. Pull the mic to you, and
I've got the routine now.
the floor is yours.
Good evening. Thank you for giving me the opportunity to express myself. I'm here about 1616 Whitehall Road.
And your name, please?
My name is Laurie Kish, and I live in Stony Creek Farm. And I would like to read a comment to you, please.
Sure.
I'd like to address anyone concerned with planning, zoning, supervising of Worcester Township. Last night, several of my neighbors and I were at the zoning meeting, and this is what I read. This evening, I'm here to say that we would like to state that we are and have been very concerned and upset about seeing, hearing, smelling, and living next to a property that appears to be an active construction, storage, and work site, as well as waste ground. The place looks like Sarajevo. There is nothing about this property that presents itself as a primary nor secondary site of a tree farm or beekeeping facility. I live 6 months a year, there are no leaves on the tree. I live close by, I'm up high, I have a very good view of it, as well as it's within my hearing. And I still hear construction vehicles in the middle of the night, in the morning, 4th of July at 5 a.m. Anyway, I digress, I'm sorry. The owner of 1616 Whitehall has already abused the property, endangered the watershed, destroyed the habitats, and openly defied and misled this township. Anyone, everyone with common sense should easily understand that there is no reason whatsoever, not even influence, power, or money, to grant any special exceptions to existing regulations and requirements. In fact, previous stop actions and required adjustments should be enforced with penalties if not complied with. And thank you for this opportunity.
Thank you. We appreciate those comments. Dan or Wendy, I know you were both at the zoning meeting last night. Maybe you could provide a quick update of that piece of the equation and, for the audience who perhaps were not at that last night.
Sure, I can certainly do that. So the hearing took place last night. Um, the went till about 10 o'clock. Miss Keish, sorry, she had opportunity to make a statement, and she did in fact make that statement. The floor was open to anyone in attendance to either ask questions or make statements with respect to the application. Um, the hearing has been continued until the September, I believe it's September 16th, next zoning hearing. The applicant's attorney provided the zoning hearing board with a memorandum of law that I will have the opportunity to respond to. So I will be responding to that. And then the board indicated that they will announce their decision most likely at the September 16th hearing. The township presented its case, the applicant presented their case. The record has been kept open in the event we wanted to present additional testimony, so that's something we'll consider. But I expected that the decision will be announced that hearing on the 16th.
Gotcha. And certainly it's this board's position and has been this position that we're not looking to make any concessions to what the zoning determination has been and what we think it should be. And certainly that hasn't changed on our board in any way. And certainly it's our intention to continue to strive for enforcement fully and completely. If you want to make.
Yes, Mr. Chairman. To the people that don't know, we did appear in court about two and a half months ago. The township, the manager, our solicitor, to listen to the judge. And it's not easy to sit there. You think you go to court and the judge would rule on it, but it doesn't work that way. And we're stuck in the middle of the township. We have to abide by the law, even though some other people don't abide by the law. We have to follow the procedures or we could be held. It could be a problem for us. So as the board, we're trying to push this along, but between delays and the lawyers hankering back and forth over different situations or points of law, it just slows the process down. I feel sorry for the people, the neighbor situation, we hear it, but we're trying to expedite this down the path, but it seems to go rather slow. It's a tough situation, but if we don't follow the letter of the law, dot the i's and cross the t's, follow the correct procedures, we lose out in the end. And when we went to the meeting with the judge, after 3.5 hours sitting there, essentially the judge said, you guys go out and decide this, go see if you can work something out. Well, by the rule of law, that's not the way it should work. You sit and look, you look at the left, you look at the right, and you come up with what you think is the right decision. But that's not the way the judicial system works anymore. So we have to work through the judicial system. We can't impose fines, regulations, a bunch of other things, and this is really now up to the judge, the zoning hearing board, and the judge. So I don't want to say our hands are tied, but essentially the board's hands are tied, as well as the township manager is now before our zoning hearing board and the Montgomery County Court. So we hear your concerns about the noise and the land. We've worked with soil conservation, everyone associated with that. They've been out to the property. They've looked at it and they've rendered decisions, but we have to follow their lead on these items.
Does anybody else wish to make public comment before the board tonight? Okay, seeing none, we'll move forward to starting with the official action items. We start with the consent agenda. First and foremost, does anybody wish to remove any items from the consent agenda tonight?
No.
No, sir.
Okay, Lou, do you want to make a motion then?
Make a motion, we approve the consent agenda for the June 18 business meeting minutes, June 17 business meeting minutes, treasurer's report, and other monthly reports for July of 25, bill payment for June of 25 in the amount of $373,366.39.
I'll second that.
It's been moved and seconded. Is there any public comment regarding the motion that's on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Aye. Motion passes.
Mr. Chairman, I hate to interrupt. There's a slight typo on the agenda where you authorized just bill payment for June 2025. I just want to bring that to your attention. Maybe we can make a secondary motion to update it for August. Or July, I'm sorry. My apologies.
What do we need to do? I'm sorry.
Section 4 there, it says on the agenda, bill payment for June 2025. That's our error. Apologies.
July of 20.
It would be July 2025. I just want to make sure we get it accurate. That's my fault. Apologies.
So do we need another motion for that, Wendy?
I'll
Want to make it?
just redo.
Redo the motion? That's fine.
Let's reaffirm that I'll make a motion to the consent agenda The June 18 business meeting minutes, June 17 business meeting minutes, treasurer's report, and other monthly reports for the July of 25, and bill payment of July of 25 in the amount of $373,366.39.
Second.
It's been moved and seconded. Is there any public comment regarding the motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Thank you, Dan. Thank you, Lou. Moving forward to the motions, first item up is going to be a motion to authorize the township manager ultimately to deal with the 2026 minimum municipal obligation form. That's a mouthful. So Dan, I'm going to ask you to give us a little backdrop on this. I know this is an annual item, and just sort of take us through it, and we'll go from there.
Sure, this is an annual item that we're required by law as a second-class township with a pension plan to sign and forward along these forms with the specific numbers regarding our pension. It is a pretty simplistic form, done every year. There's nothing really new or changed from the last X amount of years we've been doing it.
And in the packet that the residents have, do they have those numbers? Dan, I see there's two forms here.
They do.
Okay, and so we've got two. Basically, we're making the annual pension contribution. We need to authorize you to do that, which we do every year. Is there anything unique to the numbers this year relative to last year?
There are not.
Does anybody have any questions regarding the forms or the process, guys? It's in section O if you have any questions.
No, no question about that.
Okay. Then I'll entertain a motion.
Make a motion to authorize township manager in his capacity as a planning administrator to sign the 2026 minimum municipal obligation forms for the non-uniform employees, the money purchase pension plan, and the retirement plan for the employees of Worcester Township.
I'll second that.
It's been moved and seconded. Is there any public comment regarding the motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Aye. Motion passes. Next up, we're going to have a motion to approve Barry Isaac Associates as building code official. Dan?
This is part of our ongoing updates to our uniform construction code inspections. This is in sync with the second motion of the fee schedule, which we've already discussed at the previous meeting. The state requires we appoint a BCO. We did it in January. We do it every January. As this is a mid-year change, we would be updating it now. Gave it a month or two. We do have some wiggle room as far as timing, just to make sure everything was well and they integrated well, and they have been. So we ask that staff is asking that we appoint Barry Isaac as the BCO going forward.
So Dan, for the people in the audience who maybe haven't been at some of the recent meetings, why don't you take us through a little bit more in terms of the process we went through that sort of took us down this road and sort of some of the decision-making around it?
So as part of what I did is that when I arrived last September, I generally tried to analyze our policies and procedures within the township. One thing that stood out to me is historically we've had a uniform construction code inspector. What the uniform construction code is it is a state law that all townships are obligated to administer for the state at our cost. So generally what we were doing is we were doing inspections and plan reviews for every type of discipline: building, plumbing, mechanical, any sort of structural item you could think of. One thing we were not doing was electrical. We were making residents go out essentially on their own. We had some recommendations, but ultimately it was a private relationship between them and a contractor that had that electrical plan review and inspection certification. They were required to pay for it out of hand. We had no control over the costs, which were and are significant. By moving to a slightly larger company like Barry Isaac, it gives the ability to do everything in-house, one-stop shop. So if someone comes with a permit for, call it an addition with new HVAC, new electrical, new plumbing, and obviously the building itself, we can do all of those inspections, we can do all of those reviews, and get it done without sending our resident off into the private space to do it on their own. And it significantly enhances the efficiency of our process. As part of this, what we did was an RFP, which is short for Request for Proposals. We placed it on PennBid, which is a well-known RFP/bidding site, website that's public. We put all of our bids on there for everything, our road projects, everything along those lines. It was available for a month in public for submissions. We received 3 submissions. We interviewed all three of those. We interviewed all 3 of those applicants, and staff has come to the conclusion that Barry Izett is by far the best option for us moving forward.
So Dan, my understanding, and then obviously we're making a move in the middle of the year. Was it just, I know there's always ideally to do it in January if you can do it in January, but certainly making a move in mid-year is not, it happens from time to time. I guess the feeling was it's just the time was not right to make that move from the administrative standpoint.
There certainly was no benefit to our residents or the staff or the process to wait 6 more months for the sake of waiting 6 more months. The benefits can be felt now rather than 6 months from now. So I recommended we move forward now.
Right, and I guess one of the other items was, was sort of the flexibility to schedule inspections, and just allowing a broader opportunity.
Yeah, I mean, previously, our building inspector, we only had Tuesday and Thursday mornings available for inspections. And if you could not fit it in a Tuesday or Thursday morning, you were going to have to take off for work or figure out some sort of other plan. We have inspections now Monday through Friday from 8 to 4. It really does open up the ability for our residents to kind of fit, their busy schedule into an inspection there.
And the other item I sort of had made a note of from our previous conversation was the notion of project-based fees. And if you maybe could take a minute about articulate, I know we've talked more about that maybe on the fee schedule conversation, but why don't we touch on it here as well?
Sure. So a major issue in my mind with how we were doing it was we were paying an hourly fee, a flat fee, to our building inspector firm. And what that did is it did not allow the township to see what each permit was actually costing the township. There was our invoices did not have that broken down. There was no way to say, okay, you're getting a hot tub. Okay, you're getting three disciplines there. It cost us $327.43. There it is on the invoice, and that's the amount of money we're bringing in. It's a pass through, meaning the expense that the township incurs is then paid for by the permittee, the person who's granted the permit, and only that person. So by doing project-based billing, it's much more clear on what a project costs us, and we can ensure that we're getting in what we're expending on these projects.
Okay. Steve or Lou, any specific question? I know this topic has come up over the last few months, but any specific questions you have about?
I'm just going to make a comment.
Sure.
Steve, it doesn't matter. I'm just, this started in January and it was on PennBid, and I guess the 3 people did apply. The second motion is the one that bothers me more so. I did meet with Dan and Barry. It's a large company. I'm sure he's qualified. He provides a lot of things. But it's the second motion that bugs me. This is why I'm not comfortable. I mean, we do have a January reorg, and we do publish our fee schedule. If Barry wants to work for that fee schedule, then I think he's the right guy. If he does not, then I think we should maybe put it out for PennBid again. So that's my comment.
To follow up on Dan's comment, when Dan first came, first couple of months he's ironing things out, see what needs to change. One of the things he mentioned was our inspection process from being in other townships where, as Dan mentioned, a person can come, the inspector can come out 2 days a week between 9 and 11 o'clock. If they can't get in that time frame, Dan has to answer to the residents of the township. It really seems stupid. You have an inspector have 4 hours in a week where he comes, I can't get off. So based on some of the conversations we had, as I mentioned, we go to Hershey for a supervisors convention that lasts 4 days every year. And this company would be one of the vendors there. Besides talking to the vendor, Dan had mentioned something about it. So we network with supervisors from across the state of Pennsylvania, and you ask them questions about either the law firms, the engineering companies, or the inspectors. There are a lot of multitude of other things that happen within a township. So you pick the brains of the people there that are using these companies. How does it work out? And the thing that I found out, we were in a similar situation as a lot of smaller townships regarding the inspection process. The companies that were doing it the way we did it certainly had a lot of positive feedback from residents when they went to a full-time inspection company, and it seemed to work out. So based on the networking and information that I received at this past year's convention, I think it's I guess, a step in the right direction to make it easier for our residents of the township to get something done. So
Thank you both. Steve, I concur. I think we've talked about it for a few months. I mean, I think anytime you make a change, there's always some questions that you'll have to see how it transpires. We'll talk a little bit more when we talk about the fee schedule next. Um, and certainly, that was a piece of the equation as well for me, but ultimately, I think I'm ready to move forward with it. I think it makes sense to move forward with, and like anything else, we'll assess the performance and, and the staff will advise us going forward. So Lou, I certainly understand that you don't want to make a motion on it. I'm certainly fine with that. I'm happy to make the motion that, that we appoint Barry Isaac Associates as the building code official. Well, I made it, so I made it, you need to second it. I made the motion, you need to second. No worries. So it has now been moved and seconded. Is there public comment regarding the motion on the floor? Bob?
Bob Andrew, Worcester. So a lot of my comments have to do with the fee schedule, but it's relevant because I think you kind of have the cart before the horse. So you're going to approve this company, and then because you approve this company, then you're going to be in a position where you have to approve their fee schedule. So I think that they both need to be discussed kind of simultaneously. There are a lot of issues here, and the information that's been presented is a lot of fear mongering, misleading information as to how you present this. So almost every municipality, including the city of Philadelphia, which is by far the largest in the state, uses a third-party electrical inspection agency. So yes, it's convenient to have one person, but for the manager to somehow suggest that the homeowner is the one who is being put out at odds on this, the electrical contractor knows these inspection agencies and they're the ones making the phone call. The homeowner is not making these phone calls. There might be a situation where that happens, but that's typically not how that process works. But most importantly, the fee schedule is 2 times or more expensive on all of this. So yeah, it might be more convenient to have inspections 5 days a week, but did you try to work it out? This whole process is so clandestine. All that we get to see is we had no idea that you started this process at the beginning of the year. All we hear is, I've terminated the existing inspection agency and I've hired somebody else. We don't know how many bids there were. We don't know what those bids were, what they involved. We didn't have the opportunity to ask any questions. So the dictatorial decision-making process is not transparent, and now you're going to then try to force upon us a fee schedule that is significantly more, including, I'm assuming you saw all of these notes and you've asked questions on, like the presentation where it says, Barry Isaac comes with his own list of additional fees, but they're not necessarily shown or known. What do they include? Was he going to be determining what he wants to charge and when he wants to charge it. Manager has somehow suggested that this whole fee-based process is going to be just a pass-through. So in the process now, you're going to give all of the revenue to Barry Isaac, taking it away from the township. Yet, I guess the township is then abdicating its responsibility 100% to a third-party outside outfit, Barry Isaac. So how do we get control of that? So you give money away, and now part of the daily tasks and responsibilities of the Worcester staff, that's been abdicated. I'm not going to do it. So we're still paying the same amount of money for the township that we pay in taxes, et cetera, but they're doing less work. And a third party's doing it, it's costing us more money. And in addition, every homeowner who comes before you with a proposal or a permit or whatever, those fees are significantly more. Significantly more. I think that's unfair. Managers has somehow indicated that last month he said that we're subsidizing those costs. Well, we're subsidizing everything else. We're subsidizing roads, we're subsidizing parks, we're subsidizing right to know requests. Those are all things that the township should normally provide. And if I need a permit, then that's part of that responsibility. I'm not saying it should be for free, but we shouldn't be just imposing another tax on homeowners who happen to do a renovation or new construction. It's not just developers, it's everybody who lives here. And it just doesn't make sense that you're giving up 100% of that control to an outside agency that is more convenient for people because they're more available. I'm sure there's other people who are available, maybe not, but we don't know how that process took place. We don't know anything that happened, and we don't know who the other vendors were. We don't know if the process was good or failed. We didn't get any presentation. We got a unilateral decision. I made the decision. Presentation also says that Barry Isaac has been instrumental in making this a much more integrated process. You just hired him. How can you make that determination? It's a skewed analysis that's been given to you, and you guys, in my opinion, if I can't do the research, how did you do it? How are you coming to that conclusion other than the manager told me, and I'm just going to turn around and rubber stamp it at whatever cost it is to the other residents? I'm totally opposed. I mean, kind of what Mr. Betts just said, if you want to hire them to do the job that the existing vendor's going to do, and they're doing it for the same fee schedule, maybe. I'm not here to comment on their abilities. I have no knowledge. Nothing's been presented to us other than this is the company that we're going to use. I made the decision unilaterally, and I'm asking you to approve it. And I think that's unfair, that we don't have any opportunity to see that or understand how that process took place. And this isn't for a $10 procurement. It's worth hundreds of thousands of dollars annually.
Okay, I appreciate your comments, Bob. We'll talk about this a little bit more on the fee piece. We were provided information on a whole slew of, I would disagree with you on the notion that everything just went up double, where we certainly looked at not every conceivable combination, but a whole bunch of different permit combinations that somebody would have if you had this type of addition, this type of addition, this type of addition, and they were not double at all. In fact, the numbers were less with what the data presented, not necessarily on every specific combination. I would say we're not also abdicating infinitely forever. We can very quickly analyze month to month once we're doing some of those inspections to see how the actual data plays out with those inspections. The staff is still, there's still, those costs are still going to be managed and looked at. And if ultimately they don't align to an expectation of either neutral or savings or modest changes, then the board can make an assessment to that, Bob.
And
But
the analysis that you have done, is that an independent analysis, or are you just taking the information that was presented to you?
I took the information that was presented to me, Bob. That is correct.
Understood. But if that information is incorrect, then you're making a decision based on factual inaccuracies.
So, fair enough, Bob. I took the analysis that the professional staff put together for us. If it turns out not to play out, then we'll be able to address that as it plays out. But no, you are correct. I did not separately go out and run every conceivable permit combination. I did not.
I'm not asking you to do that. I'm asking you, did you check the information that was presented to you, if it was accurate, that it aligned with the information that is available to us?
What information was provided in the packet, Dan? I mean, you want to,
There's a spreadsheet, or there's a presentation in there that's got some hypotheticals on what our permit costs would be and what they wouldn't be, but I do feel obligated to say that we are absolutely not abdicating any duties that we haven't already advocated to our previous UCC inspector. If there's some sort of idea that we're advocating our entire oversight of this process to a third party, well, if we've done that now, we've been doing that for the last 20 years. Nothing is changing as far as oversight, and we are granting IZET no more powers than Keystone ever had. It's the exact same type of relationship.
so, and what I would share is we went to Keystone first. We went to them before we went to RFP to ask them if they could accommodate electrical. That was one of the items that, and they were not able to accommodate that. They were also, we asked them about adjusting their schedule. We did talk to them about the fee schedule and whether they could align to how we wanted to internally do that, and they were not accommodating to that. So certainly that would have been my preference, would have been to have them accommodate those needs and continue on with them. They weren't able to do that. What I generally want to comment, Bob, is that certainly we make an effort. So we're elected, and as elected representatives, we do our best to represent the collective everybody. But ultimately, part of what you elect this board to do is to make decisions that we hope are in the best interest of the majority of the township. If it turns out we make a decision that doesn't play that way, then we make an adjustment to it. But ultimately, the decision-making does come down to us three at some point. We do make an effort. You have certainly commented multiple times across the last months that you don't feel we're giving you enough information or in the right way or in the right combination. So certainly there's always still work to do there. But ultimately at the end, we need to make that decision or not make that decision ultimately. But certainly we're not, I think we're more transparent than we've ever been. I don't want to get into a deep debate about that, but I think we're more transparent than this board has been. I was in the audience for a lot of years. I've been up here for a number of years. I think we make every effort to do that. Do we make mistakes? Of course we do. But this notion that somehow we're trying to do some wide conspiracy, confidential, hidden, it just isn't, that's not, I don't think that's what's happening here. But I will say, and I've said it in this meeting publicly, if we make a decision like this and it doesn't prove out how we intended, then we make an adjustment to that. We're not making a multi-year commitment to this other firm if the feedback we get from residents, if the proof is not in the pudding, as they say, in terms of the numbers, then we will make an adjustment to that. I'll say that publicly. I mean, that's at the end of the day, we as a board, it's fine that Lou is not supportive, like that happens. It doesn't need to be unanimous. We think it makes sense. I think it makes sense to move forward. Steve thought it made sense to move forward, so there's been a motion and a second. Your comments are appreciated, but ultimately we'll make a decision that we want to make, and we'll continue to try to do our best to get as much information out as we can in a timely manner. You obviously expressed you don't think we did that adequately here, but we'll certainly continue to try to do better going forward on all of the decision-making we make. But ultimately, there is an element of separation where this board has to make a decision on something one way or another, And part of that doesn't always get all the information out to the public, not because there's something sinister going on. If the information that Dan provided doesn't prove out, if the analysis that Christian had done, or if the advice we get from Wendy, or if the advice we get from John, like this notion that we're just like, oh, we took their word for it and we're just going to live with that for the next decade, that's not true. That hasn't happened in the 8 years that I've been serving, and it certainly hasn't happened in the 17 years that Steve's been serving. But separate issue. We appreciate the comments. I appreciate what you said on it. Steve, certainly if you
Yeah,
want to comment.
my comment is, I've sat here for 10 managers. Some of them just sat in the office all day and just didn't do a whole lot. Dan came in, from the first day he came in, he started running and looking at things happening in the township. We all have full-time jobs. We run for office. We hire a staff that goes out and does the research. Dan did the research. I hired him, I voted for him, I have to trust him. But at the same time, I did my own research about the company. I talked to other townships across the state. You may have an opinion, great. You're entitled to your opinion. You're a resident of the township. You have that opinion. We've been voted in by the people to try to make decisions on behalf of the whole township. You know, when we sit here and look at the things we're talking about, the fees, the thing that, you know, the big bad boogoo man in the room is the school district. This is so small. Not every resident will, taxes, I'm talking about taxes and influences. I know you think it's funny, but I see the situation, Bob.
No, my comment is
I'm saying that every resident will be affected by what happens over that school district by thousands of dollars.
I'm
We're
not
talking
disagreeing with
here
that.
about the people paying their fair share, as Dan has looked at it, saying, okay, the fee schedule, he researched it, we pay him to do information, we pay him to look at this stuff, and he came up with a decision. By interviewing these companies, looking at the fee schedule, as I said before, I did my own investigation with the people that use this company, with people that have used the other company, looking at the fee schedules, and it seems to be the appropriate thing to move forward with. That's all.
just to your comment, Steve, for you to distract me by somehow suggesting that the impact of the school taxes is so much more, so this is negligible. That's not the point. That's not what's relevant. The issue is if a permit costs $1,500 and now it's going to cost $3,000, that's an issue. If you're not
I agree.
concerned with the cost to the resident of that is, or you say the only people that affects are the people who are using it, then that's, you're just colorblind. You're looking at whatever you want and you're trying to distract people. The fees are going to go up significantly. And if the piece of information that you've been presented with says, oh no, that's not, they're comparable, that's inaccurate, and I'd be happy to show you where that is inaccurate. If the whole issue is we're willing to pay a significant premium for convenience, well, you know, I'm not sure that that's the only factor that should be in there.
I don't think the thing is about convenience. Once again, my last comment will be, we hire a township manager to research the things happening in the township. He came back with a proposal that he thinks it'll work better on behalf of the township residents. We have to sit and look at it and come up with a decision. Thank you.
Fair enough. Okay. Does anybody else wish to make public comment regarding the motion on the floor? Jim?
Jim Malik, Worcester. Do we have a time limit anymore?
I'm sorry.
Do we have a time limit anymore?
Since you have been coming.
I know, because I used to come to meetings and they had the Jim Malik 2-minute rule. So I think you make a good point. I'll get to the this issue. A good point regarding the school district. Some of these people should go sit through a school board meeting when it comes to transparency and serving the public. There's no Q&A. There's no answering questions. 3 minutes and you're done. Here, I just observed something I haven't seen since the last time I was at a meeting here. back and forth, trying to answer questions, trying to engage in dialogue, which is, I think, unique to this township. Now, regarding transparency on this issue, regarding, well, we don't know a lot, you guys know everything. As a right to know expert, I think I could call myself that. Most of what you guys are doing behind the scenes with your manager and your lawyer and everything else on this issue would be considered pre-decisional deliberations. So even if I did a right to know request, I couldn't get it. Okay? I couldn't get it because you guys are in the process of deliberating this issue to make a decision which you're going to make shortly, one way or the other. As far as the bids go, I've already tried to get the bids over at the school district. Can't get them until they approve them under right to know. So it may seem like there's secrecy, but under the law, your pre-decisional deliberations are protected. Your attorney-client privileged communications are protected. And that's just two reasons I can think of off the top of my head. Now, I'm asking myself, what is the big deal when we're going from one firm to another firm with the assurance of the manager that really we're not doing anything different, right? And then you concede on top of everything else that if things don't work out, you're going to reevaluate it and maybe change it, maybe fix it, maybe do something else. So I'm not sure I understand the angst associated with this, but this is just my perspective on what you guys are doing.
Thank you, Jim. Does anybody else wish to make wish to comment on the motion that is on the floor? Okay. Seeing none, then I will call the question. All those in favor? Aye. All those opposed?
No, I oppose.
Motion passes 2-1. So the next item is connected, is a motion to authorize, let me get this correct here, excuse me, motion to adopt a resolution 2025-16 to amend the Worcester Township fee schedule, which is connected to the previous item. Dan, I'm going to ask you to give some more information regarding the fee schedule and the changes that you're presenting, and we will move forward.
Go to fee changes. Yeah, go back. So number one, I just want to clarify. It is very easy to think that the prices of these permits are going to go up significantly. Discount the fact that we've never charged for electrical plan reviews, we've never charged for electrical inspections. There's an entire non-captured fee structure that our residents were paying for the electrical side of things, which is significant. As we required stamped and sealed plans from an electrical engineer, those costs can be, for a new house, into the thousands of dollars. So I just want to clarify that while an initial glance might look like certain permits are those types of permits are more expensive, if you analyze it, you'll see very quickly that that's not the case. So as far as fee schedules, as we said last month, there are some situations, as you said earlier tonight, where some permits will be slightly more expensive. A standalone deck permit, for instance, is another $40. I've never tried to say that that's not the case, but I will say that, for an example, a new single-family home built from scratch, 2,500 square foot with 10 plumbing fixtures. Currently, if you include the third-party electric fees, could range anywhere from $2,200 to $3,300. Barry Izett has a flat cost for a new home of that size, $1,750, regardless of the amount of fixtures, regardless of the electric. One fee right from the jump, easy to understand, and actually cheaper than what our fees are now. There is a number of other fee examples I've put together. They've been made available to the public for a week. I will say that if you go back to that last view, keep going. There you go. So these are our changes. I put together a little slide about what the changes are, historical changes to our fees for Uniform Construction Code. For fun, I put the United States inflation rate in yellow. I put our fee percentage increase in red. As you can see, we raised fees one time since 2018, a 5% fee increase, and have not touched them since. Over that same time period, the inflation costs in the United States of America are almost 30%. So while I'm not trying to say needs to be a revenue generator, and it's not designed to be, I do think it's fair. Roads everybody drives on. Roads need to get plowed. Everybody drives on the roads. What not everybody does is UCC work. And I believe that a family that lives on a Hollow Road in a $3 million mansion should not have their permit costs subsidized by someone who lives in a rancher that's been here for 50 years that's not doing those improvements on their home. That's my personal opinion. That's part of why we did this and let's put this together.
So the fee schedule we're adopting, Dan, or would be adopting, in terms of what you're saying, and again, I'm going to reiterate it, we're going to beat the point a little bit, is some fees are on there that appear to be more because we weren't paying for them previously. They were directly going to a homeowner as part of an electrical inspection of some sort. So a number of those things, but there could be items that are more. Several scenarios that we ran that we tried to think is common that are based on past inspection environments. We found many of them to either be neutral or better, and there were some that were not. But you mentioned the deck as one particular item that would be more expensive, and certainly we will have the data that we can month to month look at and see and adjust if in fact, as I said, if the numbers don't play out in terms of, is that correct? Am I?
Correct. If I am wrong, I will take full responsibility for a incorrect analysis. I have no problem doing that.
Fair enough. Steve, do you have any questions?
No, I think Dan made a couple interesting points regarding his numbers. We all saw the numbers. We all heard what he said. And this is not a contract we're signing with anybody. We want to terminate it, we terminate it. But from the information Dan presented to us, the homeowner building a house can see the difference. So I'm not sure where the outrageous numbers are coming from, but the numbers speak for themselves. The manager did the work. He presented the information to us. We see the graphs. We have to make a decision based on that. And looking at the tax savings, it's a no-brainer for the residents of the township that should benefit from it. And as we said, if something happens that goes astray, it can be changed. Thank you.
Thanks, Steve. Lou, I know you sort of started to comment this on the last one. Do you want to add any additional comments? I know obviously you were not supportive of the move we made to change. If you want to make any additional comments regarding the fee structure, certainly.
I just believe we have an obligation to the resident taxpayer to not even, I've reviewed it all, and like Dan just stated, the deck fee would go up $50 or whatever, but I think we have an obligation to the taxpayer resident to maintain our price schedule, fee schedule, as we post in January for the year, for the next 4 months. And then more evaluation, and again, maybe we all should be more informed with, maybe a barrier to sit down, maybe in the township building, and sell me better on why things should go up and reasons why. I do believe things do go up, but based on my, reviews, we do set a fee schedule every January, and maybe we should wait till January of this year. And again, Barry Issett knew that when he was on Penn bid. I mean, it's out there. I mean, it's not like he had every opportunity. It's like, okay, I'll come work for Worcester, and I like your fee schedule. I'll work with you, and then we'll adopt it. We'll amend it later. So he seems like he's coming in. Yeah, and here's my price schedule. And again, there's my questions. I have a lot more questions. So right now, you guys, I have my own decision.
Okay. So I'm going to make the motion. I respect that you're not. So that's fine.
We sit up here. I think we all.
That's fine. I have no issue with that. So I'm going to make a motion to adopt Resolution 2025-16 to amend the Worcester Township fee schedule as presented.
I'll second that motion.
Okay. It's been moved and seconded. Is there any public comment regarding the motions on the floor? Bob?
Bobby and Worcester. So the manager just made a comment, and I'd like to get a clarification on that. He somehow suggested that with current arrangement because there's no electrical that the homeowner, and we keep referring to as homeowner, but it would be anybody. It would be commercial or residential who would be doing this, that they would be, because we don't do electrical, they would be obligated to go out and get a signed and stamped sealed set of electrical drawings that would then be an expense to that person who's filing the claim. With the implication, and maybe I misunderstood this, that with Barry Isaac, that that's not required. So all I want to do is understand that currently we have an obligation that there's an extra expense to do that, and that with the new application, that would not be the case, or as I would typically understand it, any permit application that involves electrical has been done by a certified electrical engineer and is presented with stamped and signed drawings. So the applicant, whether it's a resident or a commercial contractor, would have the same expense regardless. Do you understand that, or?
I'm going to ask you to comment on that, Dan.
Yes,
I,
I
I'm not
understand.
following you fully, but I want him to clarify what he said, and hopefully that'll answer.
I had to address it to you, I wasn't.
I totally understand that, but I only followed about 80% of it.
I can clear that up very quickly. So the companies that the residents had been going to, I will give you the one that did probably 80% of them is United Inspection Service. The answer's in the name, Inspection Service. They do not do plan reviews. They only inspect the work. So when you bring them a plan, their requirements were that they be stamped and sealed. It's not necessary by state law, but it was necessary. That was what their process was, because they did not have the plan reviewers on staff. IZET has the plan reviewers and the inspectors on staff. They do not require stamped and sealed drawings for residential work. Everyone for commercial work, regardless, is required to have stamped and sealed plans, as Steve probably well knows. Anything that's done commercial, regardless, requires a stamped and sealed plan. They were being required to get them for residential work as well, which is not. And that is where the additional cost is. People in Worcester will be able to come to us with code-compliant drawings that were put together by a competent electrician, but do not need to be reviewed, stamped, and sealed by an electrical engineer, and that is a significant cost savings.
Did that answer the question as best?
I've only experienced commercial work, so we had that as a requirement. I wasn't aware that a homeowner could draw up a set of plans and have it be code compliant, and that would be inspected. That's a different animal for me, and I'm not quite sure that is. I'll take the information, but I don't necessarily agree with that. I would think that every submission that was submitted would have to comply with those requirements. I understand what he's saying, but I'm not sure that I agree.
Okay. Does anybody else? Jim?
Jim Malik, Worcester. Is there any kind of a rule, regulation, or law that you guys are breaking by modifying your rates or your fees now rather than 3 months from now?
No, to the best of my knowledge, we are not breaking any law in doing that. It's just
So,
out of order, I guess.
yes, it's out of need because you need a new UCC, whatever you want to call it. So I don't understand the logic behind saying wait for 3 months and then do it at the annual meeting. It doesn't need to be done at an annual meeting, right?
That's correct.
Okay. For the manager, through you, in evaluating, because I just got a quick look at those things that were being flashed up. Has he looked at the total net cost savings versus cost increases for that fee schedule? And is it a net cost savings to the homeowner taxpayer?
So I'm going to paraphrase, but in many scenarios, it would be a savings, and some it would not.
Overall?
Correct. But so I don't know that we've mapped everything out, but certainly we ran a number of scenarios to see where there would be a savings.
He may know.
Yeah, that's exactly right. So depending on the project you're doing, as I gave an example, a standalone deck with no electric whatsoever, just a deck, is more expensive under the new fee schedule. It just is. I'm not trying to obfuscate that, but there are more situations than not where it will be cheaper for the applicant rather than more expensive.
Right, because and again, I didn't go through the presentation, but I looked at those cost savings, and the only one I saw that was more was deck
Correct.
out of those. So to me, without delving deep into it, it's either cost neutral or it may be a cost savings. That's the way I interpret what I just saw up there. So,
Thank you, Jim. Does anybody else wish to make public comment regarding the motion that's on the floor? Okay. Seeing none, I will call the question. All those in favor?
Aye.
Aye. Those opposed?
Opposed?
Motion passes 2-1. Next up, we're going to have a motion to authorize the township manager, or discuss a motion to authorize the township manager to send a letter to the Department of the Army base realignment and closing request, I guess. It was a mouthful, but we got some information. Dan, I'm going to hand it to you again. If you could sort of talk through what this is and why we might want to consider it, and then the board can discuss accordingly.
Absolutely. So as you may, I know the board is aware, and the public may or may not be aware, the old North Penn base, Army Reserve base, there's been an ongoing issue with PFAS, which is one of the forever chemicals you've heard about. It's one of the chemicals you've heard about up at like old Air Naval Base in Horsham / Grove. It's essentially a chemical in these cases with these former military bases that are derived from firefighting foam, and they have over the years seeped into the ground, and in a lot of places, unfortunately, corrupted the groundwater there. It's been in the news for some years now. So this has been something ongoing that the township has been following. Just last week, we received a letter from the Army Corps of Engineers that was gauging interest in a restoration advisory board. For that, what that is it is a board that's put together by the U.S. Corps of Engineers, and all affected parties would have essentially a liaison on this board. So obviously the township, I think technically it's any sort of potentially native group, any sort of affected community group, homeowners are even allowed to go through. There's two ways for them to gauge support. They either need 50 people to put together a petition. They have 3 weeks to do so. Seems probably not likely. Or they can be petitioned by a unit of government, including local government. My recommendation is that we absolutely send a letter of support to put together this restoration advisory board and appoint a liaison to that board. If indeed they do put it together, I recommend Christian Jones, our assistant manager. He has significant experience with PFAS in his time in Warminster. I would argue that he has Warrington. My apologies, I swap him all the time. Warrington, he probably has more experience in dealing with PFAS than 99% of the population. So we're very lucky to have him here in the township. So I'm happy to give a little more details, but it certainly doesn't hurt us or cost us anything to send a letter to them supporting the formation of this committee, and assuming they do form the committee, have representation for the township and its residents on that board.
So a couple questions, Dan. We presently work with Manco Gold. So rolling the clock back 20 some odd years, the Army was trying to give us the base. And for many years, we've said, clean it up, clean it up, clean it up. And we don't want it if you don't clean it up. And it's been idle for many years. So does this formation, does that impact that in any way? Does that change that? Does that put us in any?
It does not. It essentially puts together a public board that allows affected groups to voice their concerns to the owner, in this case, the federal government. So I did bounce it off of our current Manco Gold, our representation, and they said it can only help. There's really no way that it can hurt us. It can only help because it gives us a voice with that federal machine that isn't always easy to get a voice with. So that's kind of where we're at with that.
Any questions, Lou or Steve specifically? I know we got some information on this at the end of last week.
Mr. Chairman, probably 15 years ago, I sat here and the township was looking to acquire that property. And we did walk through that building. We looked at it, what it could be used for to benefit the township residents in some way. It's a nice piece of property. But I asked the environmental lawyer, one of the leading ones in the country, what he would do. And he said, run from the property. We should etch that above this thing, the building here, run as fast as we can. There's no reason for us to get involved. Let the government take care of it. We spent a lot of money over the years on the same environmental law firm looking into the property, and it's nothing but problems. And we're thankful we have someone staff now that has the background that worked down in the Willow Grove area that worked on these chemicals, and he knows the problems associated with it. So all I can say is run, township, run. I have no interest in doing anything. If the government wants to fund it, advise it, and do that, and come back with information to Worcester, I think that's great. But I think we just stay away from that as much as we can. Thank you.
So us supporting this would do that, ultimately. We would say the government puts the group together and we get a seat at the table or request a seat at the table. Is that my understanding?
Correct. We would have a liaison to the board, and if the general feeling was, as it certainly should be, you guys caused the problem, you guys should put that fire out, we would have a direct voice with representatives of the Army Corps of Engineers and federal government to do so.
Lou, any questions or comments on it?
No, Dan gave me a background on this is what's involved in doing. Sending a letter is not going to hurt us, but anything that help us. So, I mean, as far as that's concerned, it's easy.
Okay, I would agree. I thoroughly think it's fine to send a letter and say we support it. Ultimately, I'll ask you to make a motion, Lou.
Make a motion to authorize the township manager to send a letter to the Department of the Army base for realignment and closure of request the creation of a restoration advisory board for the former North Penn Memorial U.S. Army Reserve Center.
Been moved and seconded. Is there any public comment regarding the motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Motion passes. So next up, we're going to have, it's going to be two public hearings. We're going to do them separately. I'm going to hand it over to Wendy, but these are regarding some zoning amendment changes that we're going to discuss. And first one's going to be accessory structures. So I'm going to hand it to you, Wendy, and if you would take us through the hearing protocol.
Yes, absolutely. So, as we are entering a public hearing, we will want to suspend the public meeting temporarily. So this time it would be appropriate to suspend this public meeting, and we will open the public hearing regarding the first ordinance is an ordinance regarding an amendment of the zoning ordinance concerning the accessory structures. So I have a list of exhibits that I will run through, and then there will be the opportunity for anyone to ask any questions or make any public comment with respect to the ordinance. Then it would be appropriate that the hearing is closed and the board goes back into the public meeting and can vote on the ordinance. So what I have, the board exhibits, B1 is the Worcester Township Planning Commission meeting minutes of May 22nd, 2025, where the ordinance regarding accessory structures was reviewed. Exhibit B2 is the Worcester Township Board of Supervisors meeting minutes of June 18th, 2025, authorizing advertisement of the ordinance. Exhibit B3 is the legal notice, which is required to be published pursuant to the Pennsylvania Municipalities Planning Code. Exhibit B4 is the email to the Montgomery County Law Library of July 24th, 2025, transmitting the ordinance to the law library, which is also required by the municipality's planning code. Exhibit B5 is the affidavit of publication, which indicates the legal notice was in fact published on July 28th, 2025 and August 4th, 2025, in accordance with the requirements of the MPC. Exhibit B6 is the Montgomery County Planning Commission review letter of March 26, 2025. And the Planning Commission has indicated that they support the amendment to the zoning ordinance. And then finally, Exhibit B7 is the ordinance itself. I will read the full title of the ordinance because it summarizes the sections that are impacted. So the ordinance is number 2025-302, an ordinance amending the Township Code, Chapter 150 zoning, Article Roman numeral 3, terminology, Section 150-9, definitions, to modify the term accessory building, to add the terms accessory structures, barn, greenhouse, silo, and agricultural products, and to modify the term building height. Article Roman numeral 24, General Regulations, Section 150, 177, Accessory Uses and Structures, to modify certain provisions regarding accessory uses and structures, and to amend the height regulations applicable to accessory structures set forth in Chapter 150 zoning. So that's a mouthful. That's the full title of the ordinance, and that sets forth all of the provisions of the zoning ordinance that are being amended and impacted by this ordinance. If you'll recall, some time ago, the board wanted to look at amending the current ordinance with respect to accessory structures. So a good bit of time and effort was put into this. Dan ultimately put together the ordinance. It's been to the Planning Commission, been to the County Planning Commission, and I believe it's in a position to be adopted this evening. So now would be the time, if there's anybody here in the audience that has any questions with regard to the ordinance, or would like to make any public comments, now would be the time to do so. Okay. And does anyone, any of the board members have any questions with regard to the ordinance?
I don't have any questions. I do want to make a quick comment. So this item, Lou actually raised this item several months ago. The idea was to try to make some changes to avoid variance scenarios. So there was a couple of residents were dealing with height issues on accessory structures, if I remember correctly, and I might not have that exactly right. But Lou said, we should do something so that somebody doesn't have to get a variance every time that scenario came up. As is always the case, it cascaded to have a whole series of changes, but that was sort of the genesis of it. I'm glad we got it to a point where we're ready for adoption, but the intention is to hopefully, have some structure so folks don't need to get additional relief just to do certain things, but does still make sure that we adequately protect the township from accessory structures. That's why I just want to make that comment. And if anybody else has questions or comments, that you can certainly make them now as well.
Dan, the planning board approved everything? Was it a 5-0 vote?
The Planning Commission did recommend this ordinance for approval at its June meeting.
5-0 vote?
It was not a 5-0 vote, it was 3-2.
3-2 vote?
Board would like, I'm happy to do a quick summary of the changes, if that would help. It's up to you guys.
Please.
I could do that. So the ordinance makes some important updates to our definitions. It clarifies the term accessory structure of what actually accessory structure is. It was previously called an accessory building. There was some some places it was called accessory building, some places it was called accessory structure. That's been taken out of there. Accessory building is not a thing anymore. It's an accessory structure. We've added definitions for barns, greenhouses, silos, and agricultural products. We've also updated the definition of building height so it's consistent across our code. There was a number of sections that had how building height was calculated a little bit different, so there was certainly some cleanup work to do there. The meat of the ordinance really addresses setbacks, so we've gone with a scaled version of it, meaning the larger that the building becomes, the outbuilding, the more of a setback we're requiring you to have. So that allows people that live in smaller quarter-acre lots to still find a place to put a small garden shed, while letting someone who has a 10 or 20-acre lot put a larger pole building in the rear and let them use their property more fairly while kind of limiting out negative outcomes on neighboring properties. For instance, up to 250 square feet to acquire a 10-foot setback, which is no more or no less than those did in the previous version. That stays the same. The difference becomes between 1200 or 250 and 1200. There's a 15-foot setback. 1200 and 3000 square foot will need a 20-foot setback. And then for very large accessory structures over 3,000 square feet, it would need a 30-foot setback. The heights have also been adjusted and tweaked, so the bigger the building, the higher the height you're allowed to have. But under no circumstance, even on the bigger buildings, is the height of the accessory building going to be allowed to be higher than the allowed height of the principal building, meaning you're not going to have a small little one-story house and then a three-story hangar in the back of the property that messes with the aesthetics. It also includes some basic cleanup stuff. So a de minimis exception. So for a structure that's 1 square foot or less, and I know you might ask, well, what structure would be 1 square foot or less? A good example is a flagpole. They don't require permits. It's an exemption to that. It's kind of always been done that way, and generally it is done that way in many ways, in many places, but it's rarely called out specifically. So while we're digging through here, give it the opportunity to go in there. And it limits the height to 25 foot on a flagpole, which is the standard industry height. That avoids, if you've ever driven down the interstate and seen a flag that's as big as a tractor trailer, somebody putting a 50-foot pole in their backyard and flying a giant flag over 4 people's houses, while still obviously allowing for free expression. The last thing it did, it was another cleanup item. It removed some of the district specific. We had an accessory structures ordinance, and then if you actually dug through each district, we had height restrictions for accessory structures for each individual district, which oftentimes counteracted the accessory structure. So there was a lot of ambiguity, and if you know about zoning, you'll know when ambiguity is in an ordinance, it always goes toward the applicant, which in this case hasn't become a disaster historically, but certainly has the potential to be problematic when there's ambiguity. So we've removed that ambiguity. Everything on an accessory structure that anybody would ever need to see is in this section of the ordinance and nowhere else. So it's just an easier read. I wouldn't call it an exciting read, but it's an easier read. So it's been reviewed, comes to a recommendation with the Planning Commission. So staff is requesting that the board vote to adopt this ordinance and enact it into law.
Fair enough. Any additional comments, board?
One additional
Oh,
comment.
sure, go ahead.
On the 2 people that voted against it, was there anything substantial that should be noted as far as height or square footage or other?
I'm not 100% clear on what the issue was. There was some concern about setbacks being too close, but the setbacks at their minimum are no worse than they were previously. So I'll be honest, I'm not entirely sure I fully understood what the objections were.
But it was only about setbacks. It wasn't about height or
It was not
square
about
footage.
height, it wasn't about size, it was about setbacks.
That's all I need to know. Thank you. I'm good.
Okay.
Okay, so at this point, we'll close the public hearing, reopen the public meeting, and it would be appropriate for the board to call for a vote.
Fair enough. Lou, you want to make a motion?
Make a motion that we're going to approve an ordinance of 2025-302 accessory structure zoning amendment.
It's been moved and seconded. Is there any public comment regarding a motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Aye. Motion passes. Next item is going to be a public hearing on the childcare use zoning amendment. I'll hand it back over to Wendy so she can take us in and out of meeting again.
Okay, so we will again temporarily close the public meeting, and we will open the public hearing with respect to the ordinance regarding childcare facilities. This ordinance also has been in the works for a few months now at this point. Initially, the township was approached by the representatives of a developer who wishes to potentially develop property in the township with a child care use. And so there was a request for the township to entertain a text amendment. So that's the genesis of this ordinance. It was then reviewed and it was determined that, again, there were some additional items it would be appropriate to be addressed in such an ordinance, some definitions that our current ordinance was lacking, some clarifications with respect to the distinction between a school, a child care center, a family child care home, um, child care centers in religious institutions. So as a result of that, that is the draft ordinance that we have. That's the product that we have before us this evening. I'll run through the board exhibits again. B1 is the Worcester Township Planning Commission meeting minutes of May 22nd, 2025. B2 is the Worcester Township Board of Supervisors meeting minutes of June 18th, 2025, authorizing advertisement of the ordinance. B3 is the legal notice, again required by the municipality's planning code. B4 is the email to the Montgomery County Law Library on July 24th, 2025, transmitting the ordinance. B5 is the affidavit of publication, which verifies that the legal notice was published on July 28th and August 4th, 2025. B6 is the Montgomery County Planning Commission review letter of May 21, 2025. B7 finally is the ordinance itself. And again, I'll read the full title because it touches on all of the various provisions that are impacted. So this is ordinance number 2025 303, an ordinance amending the Worcester Township Code, Chapter 150, zoning, Article 3, terminology, Section 150-9, definitions, to add the terms child care center, family child care home, and school. Article 17, C, Commercial District, Section 150, 112, use regulations, to add child care center as a permitted use. Article 22, off-street parking and loading, Section 150, 153.b, required off-street parking facilities, to add off-street parking requirements for child care centers. Article 24, forgive me, I'm not great at Roman numerals. Article 24, general regulations to permit child care centers as an accessory use to places of worship, to permit family child care homes by right in residential properties, and to permit school and child care center uses in one building in all districts where child care centers are permitted by right. So that is the full title of the ordinance. Again, it's a mouthful, but it sets forth all the various provisions that are impacted here. So, would you like the manager to give a summary?
I would love that. And then we'll see if there's any comments or questions from the audience.
I'm happy to do so. So, as Wendy had stated, this initially whole kind of originated from a text amendment request for a developer, came for the township. So, rather than just addressing that single request, which just handled kind of one small part of it, we took the opportunity to look at the whole picture. And I think we were able to flesh it out and make it a more consistent, better ordinance across the board for our use going forward. It addresses it introduces new definitions, which we've never had in the zoning ordinance before. And if you can believe it, while it's all through our ordinance, we've never had an official definition of a school in our ordinance. So it'll add a school definition, a definition for what's called a child care center, a definition for a family child care home, which if back in the day, they seemed to be a little bit more common, where the lady down the street would watch a couple kids while the parents were at work. And they provide clarity in our zoning regulations and to make sure that we're consistent with the way these facilities are licensed through the state of Pennsylvania. The ordinance expands this permitted use in a couple ways. Obviously, the main thing is child care centers are now permitted by right in the C commercial district. They're also permitted as an accessory use to places of worship. So church, synagogue, mosque, and similar institutions can and actively are already, but this just emphasizes this is a by right accessory use to operate child care programs directly on their property. And I think that that's very important because what it does is it allows us to put some reasonable limitations on. There was some concern from the planning commission that a church could hypothetically rent out its facility and a third party could come in and run a daycare. It's explicitly written into the ordinance that it must be owned, operated, and licensed through the religious center itself. So it gives us some protection from it getting out of hand potentially. It also allows for off-street parking standards. I know there was some concern on the original that it might not be enough parking for overflow events, so we've added some percentage overflow parking required. And the nice thing about doing it percentage-wise is if it's a very small center that needs 10 parking spaces and they need a 25% overflow, we're only making them put another 3 spots in. If it's a giant facility that needs 100, it's another 25 spots. So it scales depending on the amount of people that would be potentially utilizing the facility. We also require the condition of a traffic plan be submitted so we can see how that traffic's going to flow at drop-off and pickup, which is obviously the most hectic time at these institutions. I think that's about it. There is a small tweak that we made that allows a school, quote unquote, and a childcare center to operate in the same facility up to kindergarten. You'll see in a lot of these facilities, they do provide kindergarten, so you'll be infant to K, and those K programs are generally licensed by the state of Pennsylvania Department of Education, while the child care side is licensed by, I believe, the Department of Health. So it still allows for those things it takes into account, and I'll thank one of the members of the audience for bringing that to our attention. Christine was the one that brought that to our attention at a planning commission meeting, and it hadn't crossed my mind, so it was a really good thing. So we've incorporated that in there. This was reviewed and recommended for approval by the planning commission, and same as last, I think it's a good move. I request that you vote to adopt the ordinance.
Thanks, Dan. I think when this one first came, the board collectively was supportive of trying to get child care center into the commercial district. It is allowed in the shopping center district, and that was sort of what started the whole sort of cascading down, thinking about a text amendment. I'm glad we took it sort of down a slightly longer path to get to a more comprehensive piece of coverage here. But the underlying thing was to try to solve the one problem, but not create a bunch of other ones. Certainly, I appreciate the work of the Planning Commission on this. My understanding is they had some good dialogue and questions, and I mean that's when it kind of works right. I think is there was a lot of good push and pull, and I think we got. I'm happy, obviously, with the ordinance that's been produced in terms of that. So I don't know. We should see if the audience has questions, then certainly let the other board members.
Now would be the time if anybody has any questions or wishes to make any public comment with respect to the ordinance. There's none, except the board, if the board has any questions.
Dan, the vote for the planning commission, was it a 5-0 vote?
It was a 4-0-1 vote.
4-0-1 in favor, and again, I agree, Rick, that we did take you're gonna say the long path, but I think we did our obligation to the resident taxpayer, that we clarified the terminology, and that Dan actually did the research, and I think he crossed everything, and he did, so, I think we did our homework.
Any comments, Steve?
No, I think when this first came up, I mentioned that we never had anything like this. The church has put them in, and I think, once again, through Dan, we're tightening some of these things up in the township just to make it fair for everybody. So I think a job well done by the staff to look into it and to make sure we're on the right track. So thank you.
So Wendy, I'm going to ask you to sort of close us up and hand it back.
Yep, so we will, at this point, the public hearing is adjourned, and we will reopen the public meeting, and it would be appropriate for the board to vote on the ordinance if you're so inclined.
Fair enough. I'll certainly entertain a motion if you'd like to.
Well, Mr. Chairman, I'll make a motion to approve ordinance 2025-303, child care zoning amendment.
It's been moved and seconded. Is there any public comment regarding the motion on the floor? Seeing none, I'll call the question. All those in favor?
Aye.
Aye. Motion passes. Next up, we got other business. Does anybody wish to bring any other business before the board tonight? I do not.
Do not.
Fair enough. Last option is public comment. Does anybody wish to make any final public comment? Bob?
Bob Andor, Worcester. I have one question and one comment. In the June meeting, you had in other business made a motion and voted on that. And I questioned whether that decision was legal, given that that item was not on the agenda. You said to me you did not know, but you would look into that. Have you looked into that, and what have you determined?
Do you want to comment on that, Wendy? My understanding is that what we did was okay, and I'll ask her to.
That's correct. It frankly was really a matter, it was an informational matter. Um, The solicitor was authorized quite some time ago to take any action with respect to the property, and the matter was a matter of litigation that started in the Montgomery County Court of Common Pleas. My office, as the township solicitor, is authorized to um, institute enforcement actions, which is what happened in this case. And then the zoning hearing was a direct result of that action. So perhaps it wasn't actually necessary for it to be an agenda item, but it was a matter of public information and public interest. So that's why it did came
Right.
up under other business, and it was appropriate.
We don't need to take a vote, but we certainly can discuss it publicly and sort of agree that it doesn't require the motion. So we probably should do that differently going forward.
But you did take a vote. You did make a motion, and you did take a vote.
We did, but yeah.
Procedurally, I'm not arguing that. I'm just saying what you did, I'm questioning whether that was legal or not. I'm not saying whether you should have done that way or you did it a different way. Solicitors made a determination. I was just curious if you had looked into it, and I'll pursue it as I
Okay.
would need to. I just think that it was done incorrectly, and I believe it's a violation, is just my interpretation of that. And then my only other comment would be, not picking on you, Steve, but revisionist history for you to somehow suggest that the Army base, you were opposed to it, and that the position was that you guys should have walked away from it time and time again, when in fact the board, and I believe you were on the board, I'm not sure about the timing, but we currently have approximately $1 million in reserve that was set aside for work to take place. And if you were so opposed to it all along, why would we ever set aside $1 million for that if that wasn't something we were supposed to do? So at the time, it's my recollection. It goes back a ways, and I doubt that those records are still available. But my recollection is that this board, of which you were a part of at the time, the other two were not part of it at that time. You guys were in favor of setting aside money because you were very interested in that property. And I was here for Manco's presentations and concerns about the PFAS were not the concern at the time. There were other concerns as to whether there were other contaminants on the site. That's a new one that has since come up, and it's obviously a serious concern. But it's my recollection is that you were not opposed to it at that time, and that's just.
I wasn't opposed, I'm sorry, your recollection that I wasn't opposed to it?
The board was unanimous in terms of them wanting to proceed and set aside money and proceed with somehow trying to acquire that site. Obviously, with certain concerns there, it's just you're now somehow suggesting we should have run, not just walked away, we should have run, and we should have run away. Maybe hindsight is easy to be part of that, but for you to somehow suggest that was your opinion all along, that's not my recollection of. I mean, you can certainly have changed your position and have that position now, but it's just not my recollection of how that all transpired back in the day. And we still have $1 million sitting aside.
Not a question. Bob, there were so many votes that we took back then that it was 2-1 that I objected to. And once again, you learn that you can vote against it, but it was always a 2-1 decision. But majority wins. So that was, I learned to accept that rather than creating a large problem within the township. We tried to work together with the board rather than being somebody here. Every time somebody come up, you fought and argued about it. You knew how the vote was going. So it was just a matter of principle. But
I understand, and you have that position now, and you're certainly entitled to that. It's just, you were somehow suggesting, my recollection is that the decisions of the board were unanimous.
do you remember when I asked the lawyer, the big environmental lawyer, whatever, I should know his name. Who's the biggest environmental lawyer in Philadelphia? Begins with them.
I'm not sure.
Manco Gold, Mr. Manco, he was here. And I believe our decision was based on his information. And I posed the question to Mr. Manco, I believe Joe Manco, and I said, what would you do if you were here voting? And he said, run. So that was my opinion back then, and still that was 12 years ago.
Yeah, my recollection is that Manco never gave you guys that determination, that they were circuitous in terms of how they presented all of that information. They were concerned, and they wanted to do that. But again, that goes back a long time.
Yeah,
I'm not,
right.
I mean, a lot has transpired since all of then. We still have $1 million sitting in the bank that was set aside for that property. And ultimately, if this current board's decision is we want nothing to do with it, then I think you need to reallocate that money and not just have it sitting aside in a fund specifically for that property.
Point well taken.
Thank you.
Thank you for your comments, Bob. Does anybody else want to make any closing comments? Bill?
Bill McGrane, Stump Hall Road. My wife and I, this past Sunday, had the pleasure of attending the Montgomery County Farmers Gathering, sponsored by the Montgomery County Planning Commission. It's primarily for persons whose properties are in the 319 programs and land trust in the county, but it is open to other persons. And didn't notice any other Worcester residents in attendance, but the gathering is put on by the preservation group within the Planning Commission. So they did not go heavily into the 2030 plan or the 2050 plan. They touched on it, but they focused mainly on some of interest to Steve. Agro-tourism was the primary topic, and it was held at a equine facility in New Hanover Township, and the secondary topic was my program, the equine business and development and how it makes open space in the county. It was well attended, and it is a networking event, and it worked very well for there are programs now from the Planning Commission to encourage young farmers. They're trying to find maybe unrelated but legacy people to take over farms, because a lot of the farmers want to retire and there's no one to take over their properties, and they don't necessarily want to sell to a developer, but they don't have a lot of alternatives. So I wanted to report that, and then mention that this Saturday, the Farmers Union will be holding a horse show here in the back, and the fire department will be holding the chicken barbecue dinner to have a little end of summer Worcester Day for the community. So, to share.
Thank you, Bill. I should have said it at the beginning that you are correct. Saturday is the chicken barbecue for our volunteer fire department. Anybody who is watching the video thereafter, and if you haven't gotten tickets already, get the tickets, go in person,
Sells
eat.
out
It's a
fast.
good day. Thanks, Bill.
Welcome.
Does anybody else wish to make public comment tonight? Motion to adjourn. Thank you all for coming.